You walked into the courtroom with the documentation, with the evidence, with years of text messages and emails and police reports. You walked in with the truth. You walked out wondering if you were the abuser because somehow in the span of 90 minutes, the entire narrative got inverted. Your boundaries became aggression. Your documentation became obsession. Your protective instincts became alienation. And the person who terrorized you for years stood there looking reasonable while you were made to look completely unhinged. There is a name for what happened, and it's called DARVO. And not a lot of people are talking about how DARVO actually plays out in a courtroom. So, if you have been through a high conflict custody case, a divorce proceeding, or any legal dispute with someone who operates through coercive control, you have probably experienced this. I am Cheryl Cyr. I am a licensed psychotherapist, a national board certified forensic mental health evaluator, family mediator, and guardian ad litem. I make things my field usually keeps behind closed doors public so that you have language for what happened to you. Today, I'm going to show you exactly how DARVO works in the courtroom and why it is so effective and why judges and evaluators often fall for it and what you need to understand if you are going to protect yourself when the legal system is being used as an extension of abuse. DARVO is an acronym coined by researcher Jennifer Freyd in the 1990s, and it stands for deny, attack, reverse, victim, and offender. So here's how it works in the simplest form that I could think of, right? First, deny. When confronted with their behavior, the person flatly denies it happens, doesn't argue, just denies. I never said that. That never happened. You're making things up. Second, attack. The person immediately goes on the offensive, attacking the credibility, character, or mental stability of the person making the accusation. She's always been unstable. He's been diagnosed with anxiety. She's vindictive because I left. Third, and this is where it becomes devastating in a courtroom, reverse victim and offender. The person who caused the harm repositions themselves as the one who's being harmed, and the actual victim as the aggressor. So this is not just defensiveness. This is strategic. When it happens in front of a judge, a custody evaluator, guardian ad litem, it is extraordinarily effective because the legal system is designed to find the truth between two competing narratives. And DARVO is designed to make those narratives look equivalent, and they are not. So here is something that is probably helpful for you to understand. First, judges are not stupid. Evaluators are not incompetent. The problem is structural. Family court operates on a principle of neutrality. The assumption is that both parties have a valid perspective and the truth lies somewhere in the middle. This is reasonable when you are dealing with two people who are both acting in good faith. It becomes catastrophic when one party is willing to distort reality entirely, and the other is desperately trying to tell the truth and to get someone to see the truth of what is actually happening. So, a 2017 study published in the Journal of Family Violence found that in custody disputes involving domestic violence allegations, the alleged abuser was significantly more likely to be awarded custody when they counter accused the victim of alienation. So let me say that again. When the actual abuser accused the victim of parental alienation, they were more likely to win. That is DARVO at scale. This is what happens when reverse victim and offender meets a system that is primed to see both sides. The person with the coercive control pattern often presents as very calm, measured, reasonable. They've had years of practice managing how they appear to the outside world. The actual victim walks in carrying years of trauma and they appear anxious and hypervigilant, emotional. They may struggle to articulate what happened because complex trauma does not organize itself into neat little timelines and packaging. And the court, doing its best with the limited time and information that it sees, one person looks stable and the other one looks distressed. And they draw exactly the wrong freaking conclusion. So let me walk you through how it actually unfolds. The abuser usually files first. They frame the narrative before you even enter the room. The petition describes you as erratic, vindictive, mentally unstable. It's already planting seeds. When you respond with evidence of the abuse, text messages, recordings, police reports, they deny ever even happened. Those texts are taken out of context. She provoked me. That recording was manipulated. And when you persist, they attack. They request psychological evaluations. They accuse you of alienation. They claim you're coaching the children. They tell the court that you have a personality disorder. They say you are the one who was actually doing the controlling in the relationship. And then comes the reversal. They tell their attorney and the court that they are terrified of you and what you're going to do next, that they have been walking on eggshells, that you were the abuser all along, and they were just trying to protect the children. And now you're not just defending against the abuse, you're defending against the accusation that you are the freaking abuser, right? This is the trap. This is why so many survivors walk out of courtrooms feeling like they have just lost their minds. And it just does not get talked about enough. When you are in a courtroom facing your abuser, the person who controlled your reality for years, your nervous system does not know, has no idea that you are in a legal proceeding. Your nervous system knows that you are in the presence of a threat. Your hands might shake, your voice might crack, your mind will probably go blank when you're asked a very direct question. You might cry or even sound really angry or irritated. Meanwhile, the person who harmed you has no trauma response to manage because they were not the ones who were traumatized. They look calm. They are calm. They are in their element. Controlling the narrative is exactly what they do. And the court is watching both of you, and they may misread your trauma responses as instability and misread the other person's composure as credibility. That's not your fault. This is how your nervous system works. All of our nervous systems are designed essentially the same way. And this is what they're designed to do. But it is critical that you understand it, because you may need to prepare. And this is where this all connects to something larger. The person who uses DARVO in the courtroom did not suddenly develop this strategy when there was a custody case. They've been using it for years. They used it during the marriage, the relationship. They use it with their family of origin, at work, in their friendships. DARVO is not just a courtroom tactic. It is a relational pattern. And why does that even matter to you? Well, it matters because if you can see the pattern clearly, not just in the courtroom, but across every domain, you stop being blindsided by it. You stop expecting them to suddenly operate with honesty because the stakes are high. You stop being confused when they deny something that you both know happened. You start expecting it, documenting it, preparing for it. And that shift from confusion to clarity is one of the most powerful things that you can do for yourself in a high conflict legal case. So, what are you going to do with this information? First, document behaviorally, not emotionally. The court does not need to know how you felt when they said something. The court needs to know exactly what they said and what the observable impact was: facts, dates, specifics. Second, prepare for the inversion. Assume that DARVO will happen. Let your attorney know, brief them on what it looks like. And if they're not familiar with the coercive control dynamics, give them research or find an attorney who does understand it. You might need to educate the people who are supposed to be advocating for you. And if your nervous system is already depleted, you might not have time. I also understand if you're already invested in the attorney, retainers, things have been going on for a little while, then educate them, spend some time and let them know, like, here's what it looks like. Third, regulate yourself before you testify. This is not about suppressing your emotions. This is about giving your nervous system resources so that you can stay present in that room. Work with a trauma-informed therapist before your court dates, if possible. And just to keep it, grounded and realistic, it can't be Monday and you're meeting a therapist on Tuesday and you have court on Friday. There's nothing they can do. Like that window there's not enough time. If it's May 1st and your court date is August 17th, now you've got some time, okay, to work with somebody so that they can help you to practice grounding techniques and getting to learn your body and how your body may react, and give you a plan for what to do if you start to get anxious, if you're being hypervigilant. You need time. It's not something that's going to happen quickly. Your nervous system was not dysregulated quickly, and it takes a lot longer to get it regulated than it does to get it dysregulated once it's been dysregulated over and over and over. All right. So finally, and I cannot stress this enough, do not engage in DARVO directly. Just don't do it. Don't do it in the moment. Do not argue with the denial. Do not try to prove that you are not what they say you are. That is a trap. Stay factual, grounded, and let the evidence speak for itself. So I want to close with this. If you have been through a courtroom experience where you walked in as the victim and walked out being treated like the abuser, you're not imagining that. There is a name for what happened, and it is not your fault that the system was not equipped to see through the acting that was playing out in front of them. All right. DARVO is one of the most sophisticated manipulation tactics there is because it does not just distort the facts, it distorts who is who. It takes your suffering and reframes it as your aggression. It takes your protection of the children and calls it alienation. And it works because most people, including well meaning judges and evaluators, have not been trained to see it. But you can see it now, and you have language for it now. And that will change everything in how you move forward. If you want to go deeper into understanding these patterns, how they operate across all of your relationships, not just the one in the courtroom, I created a free resource called the Relationship Pattern Quiz. It will help you identify which of the 7 relationships is most affected by the dynamics you have been living with and where to start the work of reclaiming your own clarity. The link is in the description. Take it if you want, it's free. And who knows, it might be the beginning of understanding something you have been trying to name for a very long time. Otherwise, don't forget, like, subscribe, leave a comment, tell me something. The comments help me determine which video I'm going to make next. Share it with somebody who might need to understand this themselves. Maybe you have a friend who's in the middle of a court battle. Share it. All right, that's what I've got. I will see you in the next one.